Welcome to another episode of Payments Pros, a Troutman Pepper Locke podcast focusing on the highly regulated and ever-evolving payment processing industry. This podcast features insights from our members of our fintech and payments practice, as well as guest commentary from business leaders and regulatory experts in the payments industry. I'm Carlin McCrory, one of the hosts of the podcast. Before we jump into today's episode, let me remind you to visit and subscribe to our blog, troutmanfinancialservices.com. And don't forget to check out our other podcasts on troutman.com/podcast. We have episodes that focus on trends that drive enforcement activity, digital assets, consumer financial services, and more. Make sure to subscribe to hear the latest episodes. Today, I'm joined by my colleague, Pete Jeydel, to discuss the new Department of Justice data security program that took effect earlier this year and the implication of these DOJ rules on data protection for payments companies and financial institutions. Pete leads the firm's sanction and trade controls team and is part of the white-collar litigation and investigations practice. He advises clients on regulatory compliance, M&A transactions, government inquiries, internal investigations, self-disclosures, and represents them in enforcement actions. Pete, thanks so much for joining me today.
Hey, Carlin. Thanks for having me.
All right, so let's just start this off. What is the DOJ data security program that we're discussing today?
I love to talk about this because, it's really not gotten very much attention. It's really flying under the radar. So it's important for companies in the payment space and a lot of different industries to really be aware of what this is. We'll try to cut through a lot of the complexity and just provide a high level overview of what it is. So this data security program, it's administered by the National Security Division at DOJ, Department of Justice. I think one of the reasons it's flown under the radar is that it really appeared quickly. This was a super fast rulemaking over the course of last year. There was an executive order in February of 2024 that President Biden issued that kicked this off, and then a series of rulemakings over just a 10-month period last year. So it's really, I wouldn't say rushed, but quick. And final rule came out in December. It took effect just about a month ago, 6 weeks ago in April. But DOJ has offered a 90-day leniency period. So the rules are in effect, but there's a leniency period until July 8th for companies that are engaged in good faith efforts to come into compliance, to kind of complete their compliance approach under these rules. And this is basically an acknowledgement by DOJ that this is new, it's complicated, and it's a really big deal for some companies. For many companies, it's much less of a big deal, but they've offered this 90-day window. That is not to be taken as an excuse to hit the snooze button on this. These are national security rules. These DOJ prosecutors are rearing to go with an aggressive enforcement approach. And the Trump administration has made clear that this is something they're pursuing. This is a China-focused national security rule. So it is definitely important to make use of this period through the spring and early summer to get that compliance approach ramped up and in good shape. I mean, this is really, you're seeing a lot of brand new regulatory regimes cropping up in recent years. You've got traditional export controls and sanctions. Now you've got, in the same kind of space, you've got this DOJ data security program. You've got the BIS, Commerce Department ICTS rules. You've got the new, people call reverse CFIUS, outbound investment security. These brand new, really significant regulatory regimes. It's pretty overwhelming for a lot of companies. So hopefully we can give listeners here a few minutes of an overview to kind of understand at a high level what's going on and how this may impact them.
Yeah, so it sounds like from what you said, Pete, to highlight that while many areas in the Trump administration, especially, as it relates to the CFPB, we're seeing rules being pulled back, where this is the opposite. And the Trump administration is actually saying they're going to enforce this and make it a priority. Do you have any thoughts on why the process perhaps was so rushed and happened so quickly?
Yeah, I think the DOJ got a green light to do this with that executive order from President Biden, and they've been very concerned about this for years. It's the section in the National Security Division that does CFIUS, National Security Foreign Investment Reviews, and they've been seeing data concerns in the foreign investment space for decades, for many years. focused on China when Chinese companies are acquiring US companies with sensitive personal data. DOJ and the US government, Treasury, CFIUS, have been addressing that kind of a Band-Aid approach, case by case, through CFIUS reviews. And DOJ has been saying for years, players across US government have been saying for years, we can't just be looking at this transaction by transaction. We have to have a regulatory program here. They say, CFIUS has been kind of shutting the back door, but we've left the front door wide open. And that's kind of one of the analogies that the policymakers have provided. And this data security program, it's an across-the-board regulatory regime that's meant to shut that front door by protecting this sensitive personal data from countries of concern and entities linked to countries of concern. And that is China, Russia, kind of the usual suspects of, foreign adversaries, as the government calls them.
Okay, so then let's get into what's really new about these DOJ rules. I mean, we all know payments companies and financial institutions are already required to protect customer and transaction data. So do these rules really change that picture?
Yeah, it does. It's an entirely new framework of data security. It's unlike any other regulation that applies under US law or under, as far as I'm aware, most foreign laws. So again, these are national security rules. So the kind of the foundational concepts of data privacy, like individual consent, are irrelevant here. DOJs and the policymakers have made an analogy to export controls. They say, companies can't just consent to allowing their crown jewel technologies to be transferred to China or other restricted countries without a license. And, they said similarly, there's a public interest in this sensitive personal data. And we should not just allow people to consent to the kind of broad scale transfer of that sensitive personal data to our adversaries. There's a public interest in controlling that. And similarly, other basic cornerstones of data privacy, like contractual protections, except in a few cases, are irrelevant here. So it's a fundamentally different type of regulatory regime that applies here. The contractual provisions, DOJ has just kind of seen through those niceties, and they've said, look, the Chinese government could override those protections by invoking supremacy of local national security laws, or just covertly by taking the data, as they've done. It's an acknowledgement that aggressive state espionage has ramped up, and that we really need to have a clear-eyed regulatory approach that protects against that and acknowledges it. So similarly, kind of traditional data privacy, data masking techniques, other ways that companies can mitigate data privacy risk, generally not relevant here. DOJ has said these rules apply, at least in the first instance, irrespective of any kind of security measures like encryption, de-identification, anonymization, and the like. So it's really a fundamentally different framework. And, with respect to the data itself, there's a very different scope of what's covered data here. It's not necessarily your traditional PII categories, things like criminal history, web browsing history, not covered here, not considered sensitive enough. The US government, they like to say their approach is high fence, small yard. We're not going to protect everything, but what falls within these regulatory areas, we're going to protect with some really stringent rules. So again, some major differences. There is a law that was passed last year called PADFA, the Protecting Americans' Data from Foreign Adversaries Act. And a lot of people say, well, we already know how to comply with PADFA. It's all about China. Isn't it the same as these DOJ rules? It's really not. PADFA is really quite different. There's a different scope of covered persons, quite different. PADFA applies only to data brokers, whereas the data security program is more kind of activity-based, based on any type of entity or individual can be subject to the data security program. And similarly, PADFA takes more of a traditional data privacy approach. If an individual requests or directs a data transfer, then PADFA says, generally speaking, that's okay, not going to be regulated. Whereas again, DOJ doesn't allow for that type of consent in this national security context.
And Pete, you mentioned at the top of the episode, some companies will be greatly impacted and others not as much. So can you talk a little bit about what companies will be impacted by this?
Yeah. And maybe, it probably makes sense to kind of step back for a second and just understand what these rules cover. So they apply to sensitive personal data of US persons, and there's specific categories of data that fall within that, as well as certain types of US government related data, which is treated as being particularly sensitive. So if you have these types of covered data linked to US persons, and you have a country of concern or an entity in a third country that's linked to a country of concern like China or Russia, then these rules may apply. So the companies that are primarily impacted by this, as far as kind of my conversations and clients have been concerned, a lot of them are companies with Chinese ownership, for example. If they rely on the parent company or vendors in China to carry out some of their essential functions that essentially require the data to be accessible within China, those companies are having a hugely difficult time complying here. That whole construct is largely inconsistent with DOJ's objectives under these rules. Basically restrict the availability of this sensitive data in China. But, essentially any international company with covered data in its possession, in its systems, may have compliance obligations here. And those will vary based on the type of company, the exposure to the covered data, exposure to China or other country of concern. But I should say even many purely domestic US-based companies will have to take compliance steps under these rules. It is certainly focused on international data transfers, but for example, DOJ is going to be publishing a list, basically like a sanctions list called the covered persons list. And they've said that may include US-based entities or even individuals that they have national security concerns about. So that may kind of require companies to engage in a new type of basically a sanctions screening process, but with a really unique lens for these data security rules. So the impact will vary quite a bit, but most companies, nearly all companies that have covered data, are going to have to worry about these rules, take steps to comply with these rules again during this 90-day leniency period that applies until July 8th.
So that's really interesting, Pete, about perhaps running a new sanctions screening, basically, like many companies already have to do. Can we talk about the exemptions from the rule and how did those work?
Yeah. So the DSP sets out some really harsh rules, quite intimidating for a lot of companies. The good news is the exemptions. There's a handful of exemptions. Some of them are quite broad. So for this audience, I think probably most relevant is the financial services exemption. It is very broad, but it's not blanket. It's not a kind of industry-wide across the board exemption. It applies to data access activities that are ordinarily incident to and part of the provision of financial services. So the key language is ordinary. Is it ordinarily incident? So, again, it's pretty broad, but it's not going to include all types of data access in China. If you have kind of an odd or unnecessary partnership with a Chinese company or employee based in China, the exemption's probably not going to apply. And what I mean by odd or unnecessary, it's not ordinary. For example, if that China connection is not related to the provision of a service in China, you're providing a service that is entirely within the United States among US persons, US merchants, US consumers, or it's between the US and the UK or what have you. Has nothing to do with China, but you have an employee based in China that needs to access data because that's where you've found talent, you've got an employee there, or you have an investor who's based in China who maybe sits on the board and has certain types of data access as part of the supervisory responsibility. That's odd, that's unusual, that's not ordinary for the provision of a service in the US or outside of China. In contrast, if you're providing a service in China, you may, for a variety of reasons, be essentially required to or be quite ordinary to have, localized data in China, work with Chinese partners, Chinese regulators, and the like. And so that's really what the exemption's meant to capture. Activity that has a normal link to China, where Chinese partner or what have you is kind of an ordinary feature of providing a service, typically in China or where one of the parties is in China or another country of concern. When that's the case, this exemption is actually quite broad. So, bottom line, it's quite nuanced when it applies, but when it does apply, it's very broad. And the exemption lists a bunch of detailed types of financial services. It's an illustrative list. What is a financial service here? It includes payment processing, funds transfers. It also includes a bunch of ancillary services like dispute resolution, fraud detection, things like that. So again, when the exemption applies, when the link to China is ordinary, the exemption is pretty broad.
So what I'm gathering from this, Pete, is if a company that engages in financial services has a vendor with access to data, and that vendor has a location in China with access to personal customer information, if it's ordinary, it is likely okay. Is that understanding correct?
That's basically it. And, your tone and the way you said that really highlights there's a lot of gray area here. I mean, they literally used like 7 words. I'm counting them right, 8 words to kind of capture the scope of this exemption. And as you know, when you get into specific cases with clients, it's not going to be simple. Is this ordinarily incident to the provision of our service? There's a huge scope of gray area here. And there's a lot of ways that you can tackle that. There is a formal advisory opinion process that DOJ has put in place, and that will essentially open in July. They basically said, please don't come in for the time being, but once the rules come into full effect or the leniency period's over, they've said, sure, at that point you can come in. I suspect it's going to be a challenging process to get real clarity from DOJ and to get that in a timely manner. So I think companies shouldn't be overly optimistic about, just leaning on DOJ. They're open for business. They will be in July anyway. But a lot of this comes down to the framework of these rules. The DSP is based on the authority of the International Emergency Economic Powers Act, IEEPA. It's the same legal framework that applies under U.S. sanctions. It's the same National Security Division at DOJ. These are people who grew up with sanctions. And so really it's kind of using good judgment to apply a risk-based compliance approach. These are National Security Division prosecutors. They're focused on real national security risk areas. And so they want companies just like OFAC at Treasury administering sanctions. They say take a risk-based approach. So when you're thinking about, does this really ambiguous exemption apply? Think about why that exemption is there, the policy purpose for it, and how DOJ would likely construe it based on the national security policy that underlies this and kind of a traditional IEEPA risk-based compliance approach. Now, that sounds like a whole lot of jargon, but there's decades and decades of learning that kind of goes behind that people can help companies to make good judgments here. Now, that's not going to necessarily get you absolute clarity and certainty unless you go into DOJ and get a written advisory opinion. So that, for many companies, that's going to be the way they need to do this to get that certainty.
What are the penalties for non-compliance with this?
Yeah, so it's an IEEPA authority. So it's essentially the same penalty framework that applies under sanctions. Civil penalties of, it's inflation adjusted, it's like 360 something per violation. So again, it's per violation. The government can define that in all kinds of ways. Each data, each event of access, we'll see how DOJ defines that. They've not been clear about that so far, but the expectation is that they'll readily seek to multiply those violations and get the penalty amounts up significantly. So civil penalties, or for willful conduct, criminal penalties up $1 million per violation, 20 years imprisonment. Other rules will apply too, like the federal conspiracy statute and the like. So, like sanctions, the penalties are really significant. But again, I think what companies need to come back to is, what's the starting point? How do we approach this initially? A lot of companies are really overwhelmed, confused by these rules. And again, it's starting with the basics, understanding whether you have covered data in your systems. And not to put in too much of a plug, but at Troutman, we've done a lot of work on this already. We've got off-the-shelf questionnaires that, for our clients, we can send you kind of these off-the-shelf materials to make this manageable, walk you through it really step by step to assess whether you have covered data. And if you do, are your counterparties subject to these rules? We have questionnaires and flowcharts that we can send that will really make this manageable for companies that are really starting at the beginning or, reassessing their compliance approach here. And then at the end of the day, if when you get into the real tough areas like the exemptions where it's gray, it's not black and white, there's a lot that we can do as outside counsel to help companies make these judgments. Again, what are the highest risk areas? These National Security Division prosecutors are not going to be looking to make cases based on minor technical missteps. They're going to be looking at the serious national security risks. That's going to be their priority. And so companies need to reflect that in their compliance approach. What are the real high risk areas that our company is involved in? How would the government view it? And let's focus our compliance approach on these priority areas. So I think with that type of framework, companies can go forward and develop a compliance approach that's going to work and that's going to satisfy DOJ.
All right, Pete, thank you so much for joining us today. And thank you to our audience for listening to today's episode. Don't forget to visit our blog, troutmanfinancialservices.com, and subscribe so you can get the latest updates. Please make sure to also subscribe to this podcast via Apple Podcasts, Google Play, Stitcher, or whatever platform you use. We look forward to next time.
Thank you.
Copyright Troutman Pepperlock, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepperlock. If you have any questions, please contact us at troutman.com.